with the case as the title. And the reason why I like that is it kind of serves as a publicity device to kind of make a Google search inquiry to draw attention to why this is an important case. 2019, Laura Cooper Fenimore, an individual plaintiff-appellant versus BLACHLY-LANE County C.E.A., an Oregon cooperative, and Cliff Kelly, an individual defendants respondents. Lane County, wow. So plaintiff, an individual who has a disability and is wheelchair dependent, sued defendants, a private electrical cooperative, the cooperative, and its president and chairman of the board of directors under Oregon Revised Statute 659A.142 parentheses 4. That statute prohibits places of public accommodation from discriminating against customers or patrons who are individuals with disabilities. Plaintiff sought damages and injunctive relief after she was unable to attend a board meeting of the cooperative that was scheduled to be held in a conference room that was not wheelchair accessible. The trial court granted summary judgment in defendant's favor. For the reasons explained below, we conclude that plaintiff cannot sustain a claim for damages under ORS 659A.142 parentheses 4 against defendants. We also conclude that plaintiff's claim for injunctive relief is now moot. Accordingly, we affirm.
There you go. All right. So, unless you want to read the whole thing, like you don't. You want to jump down to almost the bottom.
Okay. Plaintiff's claim for injunctive relief is like the last section.
You go up from that.
Okay, up from that.
Because the reason that the injunctive relief was moot was that they moved to a new facility that had a wheelchair accessible ground floor instead of the second floor story that they were doing. So since they weren't going to be meeting at the place that was not accessible, the court could prohibit them from meeting in a place that wasn't accessible. Right? So anyhow, that's why he declared that the injunction was moot in that particular case. But if you go upstream from that, the last thing pretty much that they say is, there's what do they call it now? Alternative, right? Is that what I'm saying? Alternative reasons for
right. This alternative basis to affirm section, the second paragraph says, first, the facts in the record are sufficient to establish the plaintiff was not, at any relevant time, an actual or even potential customer or patron of the cooperative. The undisputed evidence at summary judgment established that plaintiff is not a member of the cooperative, nor has she ever been eligible to become a member. As noted, plaintiff did not reside or work in the cooperative service area and therefore could not be a member of the cooperative. As a result, at the time of the board meeting, plaintiff was not capable of patronizing or purchasing services from the cooperative, which sells electric power and provides the related services exclusively to its members. Plaintiff averred to the trial court that she wished to attend the board meeting solely to observe and provide advice to the Lemlers based on her observations. Plaintiff did not present any evidence that she had attempted to engage with the cooperative, attend the board meeting, or enter the cooperative's headquarters for any reason even tangentially related to purchasing goods or services offered by the cooperative, or that she had potential ability to engage with the cooperative for that purpose. Then second, the trial court's summary judgment ruling is consistent with our view of the evidence under the alternative basis, where there is no factual dispute that a plaintiff in an action brought by ORS 659A.142 parentheses 4, I don't know if you say section 4 or what that means, is not a customer or patron. The defendant in the action is entitled to judgment in its favor as a matter of law because the customer or patron status is an essential element of the claim. Accordingly, where the plaintiff is not a customer or patron of the place of accommodation, summary judgment is warranted on that basis alone. Oh, Barry, jump in. Explain this to me.
Okay, we've got our statute, and it's 659A 142.
Okay.
And that has a number of numbers, and usually it's numbers and letters and numbers and letters, right? They'll go to capital letters and small letters and Roman numerals, and there's all these various iterations of stringing things out. But in this particular 659A.142, there's not that much compared to some other things. Okay, so this, however, gets tricky because it has two great examples of how to really get messed up reading anything. Okay, so if you go to 659A 142, right, and then you go down the list to number 4, it prohibits discrimination against persons with disabilities by public accommodation. And then it says in that sentence that to know what a place of public accommodation is, you go to that other statute.
Barry, are you telling me you're better at reading the law than the judge? You're finding this secret magic formula?
No, I'm not saying that. I'm just saying that so you read. Okay, so then, hang on. Let's just let's just do this, right? Let's do this real time. Okay. And then everybody that wants to know, including you, will know exactly what you did.
Okay.
Okay, you have to access, basically, to analyze this case, you have to access a couple of things. One is the actual statute, 659A. So if you get yourself on the screen,
I'm on OregonLegislature.gov/bills/laws or 659A. Yeah, I'm on it.
Yeah. And you want to do the official one because there's other versions that they'll give you like a little snippet. You want the whole thing from the it's from the Secretary of State.
Mm-hmm.
Right? Is that what ultimately that's what it says there, right? So okay, so you go there and then you go to 659A 142.
Yeah.
And it has number 4. And so you start reading that sentence. And when it gets to as defined in, then you have to go all the way over to 659A.400 to see what that sentence said. Because everything at 400 is now in that sentence because they said so. So before you even get to the next word in that sentence, you have
place
to go
of public accommodation defined.
And then you read all of those.
Whether or the service is whether the service is commercial in nature, as to whether, regardless of whether the service is commercial in nature. That's bingo, right?
Right. No, that's the lingo for the part about government. Local government. So that would be Tinkerville County or whatever.
Mm-hmm.
Okay, but that's not the thing. We're not even done yet. Okay, so what government are they talking about? You have to go then to government bodies as defined in, what is it, ORS Chapter 170?
Okay. ORS Chapter 170, okay.
Right, that's in there somewhere, right?
Let me see. Okay, yeah. Okay, youth correction 174.109 as defined in ORS 174.109. Yeah, any place that is open to the public and owned or maintained by a public body. What is semi-governmental, quasi-governmental?
No, hang on. So just read what it says for a second here. Okay, so you're speed bumping down the trail here, trying to figure out where you're going, right?
Uh-huh.
So you get successfully to 659A.142, and you get successfully to number 4, and you start reading it. And before you get to the end of the sentence, you have to go over to 400 to see what that says. And that's where you just were.
Okay.
And then when you're in 400, right, still being in, section 4 back there, right, when you're reading that part, it says government bodies as defined, and it has another statute. Right?
Yeah. Government as defined by any service to the public, so any place that is open to the public, any place offering public accommodations. Okay, discrimination of public accommodations prohibited. Aiding
No,
or...
No, you got to stay in 400.
Okay, I'm on 400. You want me to look up the 174109?
Is that what it says, public bodies as defined in?
Yeah, let's do that.
Okay, so that's you're still back in that same sentence in 142 now. And you're already down to 400. Now you're going even over to another chapter. And then you have to go there and see what that says.
Uh-huh.
What kind of public body? What's a public body? Right? So, and that's defined. And so, all of those places you would have to be a patron at all of those places.
Do you know much about this electrical cooperative? What the heck is that? I'm kind of confused when I hear that. Is this like I'm thinking it's like a union or a power company?
Yeah. They've got their own thing, and they're all members, and they're paying.
Oh, yeah, it's defined in the first few paragraphs.
Thing,
okay.
Right?
You pay a membership fee.
Right?
Okay.
Right? Yeah. Right. Right. Okay. So
members may attend board meetings. Okay. Non-members are not permitted to attend the meetings except as a guest of a member, and may not participate in the meetings except as an observer. So she doesn't live in the area, so she's not eligible for membership. And is a power company a government body? I don't think so. This is like a grocery cooperative. It's a cooperative, but it's for electricity.
Right.
It's a club.
So it's not. Yeah. So it's not such a. It's not that case wouldn't control those other things.
Yeah.
It's on your list of ORS 174 public bodies is free game for protection in spite of that case.
State government Okay. Secretary of State Administrative Rules. Maybe I've got a good copy here. Let's see. Standards.
No, what are you doing? You don't want administrative rules. You want revised statute.
I want, section ORS 174109. Okay, public body is defined. Oregon laws. Let's see. Okay.
Now you're getting smart.
109. Wow. Public body defined. Okay, means state government bodies, local government bodies, and special government bodies. What does special mean? State government defined, executive department defined, judicial department, local government, and local service district. Does this sanitary authority, a fire protection, vector control, a metro service district. This is where all this stuff falls. Mass transit, a park, boom. Because this is actually so relevant to stuff I've been studying. Is how can the park district have like a 4-year vendetta on me for reporting their predator who is their employee. Like where all civil rights, ADA rights, non-discrimination, non-retaliation rights. I mean, they're so... I've got Eileen Eakins up in a bar complaint. I think I might have surprised her because, of course, they want to do an exoneration. I actually found a really great blogger called Stephanie Volin, Volin. She is on the Oregon State Bar for some of the shady stuff they do, including when a lawyer is super tarnished, they will let you resign and stop taking fees, and then they call you a pro bono lawyer. You become a pro bono lawyer for the Oregon State Bar, thereby creating a legal shield of client confidentiality with the bar itself. So the bar that is investigating you is now hiring you as a pro bono lawyer. And that's how they protected Terry Bean's victim's embezzler, whose name is Lori Devaney, who embezzled a $200 settlement to shut up and gag and intimidate the witness of Terry Bean's child rape and sodomy, keep him out of court or terrify him out of court. And then the collaborator with Lori Devaney, who was sort of like a fake lawyer who's just screwing over the victims left and right. Like, here, get you in this little hush money settlement, wipe out your settlement. She got a sweetheart deal with the Oregon State Bar. And then Derek Ashton, who was Terry Bean's lawyer, was collaborating with her. And the journalists are like afraid to state how extreme this is. And they don't really want to spotlight how corrupt and crooked the whole county or the whole state is. But then Derek Ashton just moved to gag the whole thing because he and Terry Bean got arrested, and Terry Bean still is going to be prosecuted in the beginning of 2022 for these crimes in like 2013 or 15 or something, because the victim's finally coming forward, and the victim still got tarnished with the "you got hush money" paintbrush, even though his lawyer embezzled him and his lawyer was colluding with the rapist's lawyer to screw over the victim and make the victim look bad. And this is a child. It's so freaking infuriating.
Oh my goodness.
Yeah.
Okay, so if you're not the one and it's not the time.
Yeah.
If one were to read all of those governmental body statutes, right, as defined in, what number was that? 174?
Yeah, 174, but 174.116 looks like where it gets really juicy because it's the laundry list. Water supply, cemetery maintenance, park and recreation, people's utility district, as defined under ORS 261. Metropolitan Service District, transportation, mass transit, library, county road, special district, highway lighting district, communications district, health district, sanitary authority, water authority, geothermal heating, irrigation district. Yeah, no, I think they're screwed. I think they are a public service, even if they think they're a private. This is like a privatization of water type thing. Weather modification, fair district.
So anyhow, let's give the Oregon Court of Appeals the benefit of the doubt that they got the decision right. I can't see how it could apply to the library because you're a patron of the library, whether or not there's commerce involved.
Right.
And see, I guess what you have to do is you have to go up in the case. You have to find out the part where he actually, where the opinion defines customer and patron to be essentially the same thing.
Customer and patron.
It'd be the very first part of the statutory construction.
Barry, are you really a Libra? Is that where we're at? I'm a Leo and you're a Libra. Is this straight?
no. Why would you even ask? What stars have?
Well, because you have a certain kind of mind that is all into this meticulous stuff, and it makes me feel crazy because I'm more of a broad strokes, like, woo! So I just want to get straight to the point, and this is just a bunch of like red tape, and it's annoying me, and it's convoluted. It's like catechism class.
Exactly. Right? We're in one agreement. I agree with you entirely.
Yeah.
Okay, so I'm gonna find it for you because it's right here on my. It's right here on my Android. So. All right. Okay. So anyhow, in the opinion, what they talk about is how Oregon has a statutory policy that actually, makes protecting the civil rights versus the disabilities a public policy, and that the Oregon statutes are supposed to be in lockstep with the FDA, or not the FDA, but the ADA, right? So here we go. Right above number 2, context of ORS 659A 1424, right above that, it's full print thing, number 2.
Okay, where are we? 659A 124, is that what you said?
No, in the case.
Oh, yeah,
FENIMORE.
okay, back in the case. Ooh.
Yeah, go to FENIMORE.
So, okay, I'm seeing some number pagination, 704, or plaintiff's claim for damages.
No, you're going to go to the bold headings.
Yeah.
You got it.
Factual.
Interpretation of ORS 59A, and under that's go to number 1. It says
Okay.
ORS.
When interpreting a statute, we examine the text and statutory context as well as the legislative history to the extent that it's helpful to discern the legislature's intention in enacting the statute.
Where are you at?
Okay, so it's, kind of almost midway. A, interpretation of ORS, text of ORS 659A.
Yeah. Text is number 1.
Okay.
And you want to go down to where it says number 2.
Context. Okay.
And then you want the paragraph above that.
Okay. Yeah, in 73, the legislature first enacted the prohibition on discrimination by a place of public accommodation against a customer or patron on the basis of disability. See or laws 1973, CH 660. 7. Contemporaneous definitions of customer include one that purchases some commodity or service, and then one that patronizes or uses the services as of a library, a restaurant, a theater, a client. Webster's Third New International Dictionary, 559, unabridged edition 2002. Other common definitions include a buyer, purchaser, or patron. Black's Law Dictionary, 462. Contemporaneous definitions of patron are not dissimilar and include a steady or regular client as a habitual customer or merchant. Webster's 1656, and a regular customer. Black's.
Okay, so what is a library, which is just right there in that same paragraph?
Yeah.
Right there, you were just there.
Yeah.
And right?
Yeah.
A customer includes one that purchases some commodity or service and one that patronizes or uses the service, and then in parentheses, of a library, restaurant, or theater. So being a customer of a library is apparently appropriate according to Webster, right? That's what they're telling us.
Yeah.
A customer include, right, contemporaneous, so they're saying back in the day, right, when wasn't 1773, right? This was 1973. So,
right.
So anyhow, they're saying that definitions of customer include. Well, I would suggest that the definition of patron would include somebody that goes to a library.
Yeah.
And you know how you know that?
How?
Well, we're going to test these guys. Let's go to Google Scholar again.
Oh,
and then put in patron and library, where it just did.
okay.
That's how you go. Right?
Right.
Go back. That's how you go here. And this is about 16.
Okay. Do we want to look at one of these other cases? State v. Davis?
Yeah. What's the say?
Ooh, we got a library book theft of 50 books in Clackamas. That looks juicy. Oh, man. I feel like, crying. It's book. I love books. Books. Okay, Nearing and Weaver. I don't know what this one is. 1980.
Wait. Did you see State versus Davis?
Yeah, should we look at that?
No, well, even options that the Google Scholar gives on the search, right? It says It says defendant was charged with 4 counts of theft for checking out a total of 50 books. The maximum number that one patron may check out from the Clackamas County Library system. From 4 Clackamas County libraries and failing to return them, right? So a patron is a person that goes to the Clackamas County Library and checks out the books.
Wow.
And Clackamas County Library is part of government and is therefore part of a public accommodation, whether in commercial nature or not.
Right. Okay, but I just want to cry over these books. I'm sidetracked on the plight of the book. You know, I mean, isn't Multnomah still like 130 books? Something miraculous, like an extreme amount of books? Like more than you can carry physically?
What? Yeah, but what you're missing is
It's patron.
You went to the Clackamas County Library and they discriminated against you because you had a disability.
Yeah.
And you brought an action against them. You would have to prove that you were a customer or patron, or your case would be dismissed.
Right.
Because that's what they're saying, the language of the statute 659A 1424 mandate. If you're not a patron or a customer, then you don't get the protection, and that's what happened to FENIMORE.
Oh my gosh, this kid like sold some books to Powell's. Powell's is all up in this case. This is crazy, but it has to do with the Friends of the Library book sale, or maybe he took books from the book sale, got this confused. Oh my gosh, 500 books, arranged to sell them on Craigslist. Okay. Should I go check out the other one, Nearing and Weaver?
Why does it say what a patron is?
No, I don't know what it says. I haven't looked. Hillsborough Abuse Prevention Act, protection for persons threatened with assault by a present or former spouse or cohabitant. Huh. Guardian ad litem type of a thing. Her 2 children was separated. It looks, arresting husband for... I don't know why library and patron brought it up. Well, hey. Okay.
There you go. All right. So the FENIMORE. So what one of my defendants opposing me through their attorney said was that anything that happened at City Hall wouldn't be protected because it was civic and not commercial.
Mm-hmm. Civic, not commercial.
But it specifically says that public accommodation in Section 400 there includes a government service, whether or not it's commercial. So it says so right in the definition of what a public accommodation is, that if it's the government service and it's not commercial, that it doesn't have to be commercial to be a public accommodation. Like the fire department, or the library, or the,
Mr.
water.
Stull, is there any way to simplify this? I mean, do we have a future, or is this all just going to stay overly convoluted? Can we just have a simpler version of a castle where everyone is happy, like a utopia, or lots of rights for everybody, or freedom and happiness for all? Something simple.
Yeah, you just talked about it. It's not ours.
It's all ours. Okay, we can get through this. I think,
You're right.
yeah.
We have that castle, but it's not ours.
Yeah. Okay.
Yeah. Okey dokes.
Well, are you getting hungry or something? It does seem to be approaching a dinner hour if one was regularly fed.
I've got to do something.
Okay, well, Barry, I've enjoyed it. I love our show, and thanks for giving me some cases to look up. It's awesome being back in touch.
Okay, so to unfold it, here's what you learn. You learn that if you go to a particular case, it has some ways to determine what a statute means, right?
Mm-hmm.
You know what you've done is you expanded, because of the 2019 FENIMORE case, expanded the language of that statute by incorporating that into it. Because now it's context. The Court of Appeals opinion is now context that you have to read in order to understand that simple line. You read one line across the page, and it sent you to another part of the same chapter, and then that sent you to another different chapter. And you have to know all that stuff.
Ooh, wow.
Or you don't.
Oh, you don't? Well, I like how this I'm copy-pasting all of this. I want more people to know about library patron law. This is just the most exciting. This is like art law. This is somehow really juicy to me, and I think it's this inherent greed I have for books that I inherited from my dad, and like growing up in libraries and hanging out at book sales. And my dad was always trading books, and like 3 boxes of these books for 2 boxes of those books, and replacing editions. It was so fun being his kid in a weird way, because it was like this magical treasure hunt of information, but it was all very tactile. But I think he knew the internet was coming before he got like his dementia, because he kept talking about it. He was like, the infinite data, because a lot of the library system was really computer data based as well. So like he did a lot of interlibrary loan. And he would actually, right before he completely lost his wits, he would sit there at the family computer Googling himself and just like cracking up at how cool it was he was a book author and had written books that were indexing to Google. He just thought Googling his own name was like hilarious. It was adorable, because it's true. Like he made his little permanent record, and they're in little libraries here and there. And he was known for science fiction, fantasy, horror, poetry in the 70s before I was born. But then he moved on to like some biography, commercial efforts. And then he stayed doing poetry his whole life. But he did like random literary scholar, like literary analysis of random niche market type poets and things that basically nobody cares about. So it would be like a little fan club with like conventions, kind of like the equivalent of zines, like zine culture. Very obscure and very non-monetized, I would say, in my starving artist family. With my tough breadwinner nurse mom at the helm, bringing home the bacon so my dad could be like a starving artist. What a good role model. One or the other of them.
All right. Well, I'm sorry that your legal research got you down the rabbit hole of somebody ripping off the library.
Oh, it's so juicy though, but I have to tell you, I will confess, I mean, I dated a librarian who expunged my record when my Samuel Beckett got eaten by the sun and the sun melted the glue in my Samuel Beckett. And he just like erased it in the system. My Brian Bowling, my librarian guy friend, boyfriend, whatever. And then I also had another thing where I got carjacked with some really rare German books. And the secret, like, Los Angeles library guy, he just, like, zilched $140 worth of replacement fees. When I showed him my LAPD crime report, he was kind of like, well, this really sucks. You just got hit on the head, mugged, and carjacked, and, like, you need to, like, also pay the library fee? Because I was even trying to negotiate. I was more concerned about my rare edition 100-year-old German books from the Los Angeles library than my own life. I was like, but my books, like, surely you don't want my rare philosophy books, do you? Like, I gotta take those back to the library. It was so...
All
right. Nice talking to you, Bear. Bye.
All right, I'll talk to you later. Bye-bye.
Bye.